Bill Kinnock.
Hello, thank you very much for coming today. I just wanted to understand a little bit more about the EEA-EFTA relationships that exist in this context. So, obviously, as I know the Centre for European Reform has pointed out, and others, Norway and Iceland have a multilateral extradition treaty with the EU, and the procedures are very similar to the European arrest warrant. But the indications are that there's some complexity and difficulty in that treaty that took, I think, 13 years to agree and ratify, and still hasn't been ratified by some member states. Can you say a little bit more about why that's been difficult? Because one would assume that it would be easier to draw up terms with those countries than it would, for example, with the United States, or if you like, a more distant country with a less integrated relationship with the European Union. So can you just say a little bit more about why those difficulties occurred?
Right. First, perhaps on terminology, I think the EFTA-EEA analogy here doesn't necessarily work, because we need, in the just and home affairs area, I prefer to distinguish between Schengen and non-Schengen countries.
Yeah.
Just taking into account, for example, that the EFTA court does not have jurisdiction over just and home affairs. Yeah. And that was a very early kind of mistake that was made in the conversation of whether the EFTA court could have a role on this area. When it comes to extradition arrangements with countries other than those in the European Union, we have three types of extradition arrangements. So we've got bilaterals, which is the case of Switzerland and the US as well. We've got what we call mutual legal assistance treaties, which actually supplement these bilaterals, which is also the case of the US. And then we've got the multilateral, as you rightly pointed out, which is the one in between the European Union, Norway and Iceland. In my view, the reason why this is taking so long to negotiate, it's precisely because of the issue of court jurisdiction, because they need to find a way to have a court that adjudicates questions of criminal procedures, fundamental rights. There's no way you can get away with an extradition treaty with no court jurisdiction whatsoever. Now that took some time, and in the way the Norway, Iceland, European Union treaty solved that question was to establish some sort of a mechanism. Now nobody knows what this mechanism means, how will it actually work, who will be part of it, and how a mechanism, which is not a court, can actually decide on questions that I was referring before as of whether or not you can imprison somebody, or whether or not you can breach somebody's, presumption of innocence, or these sort of things. Another question that was difficult as well was the famous question of whether or not to extradite own nationals to Norway and Iceland. And that is taking a long time to negotiate as well, because, as you very well know, the European arrest warrants basically abolish the constitutional ban on extraditing own nationals. So now every single member state of the European Union is bound to extradite their own nationals to other member states under the European arrest warrants. That doesn't happen outside of the European Union for legal and jurisdictional reasons that we can talk about later if you want as well. So the Norway-Iceland treaty had to work around those problems as well, and it took a long time for member states to decide whether or not they were going to extradite their own nationals. And I think I have the numbers somewhere here. I think at the moment something like 14 countries have said they will extradite their own nationals only under conditions to Norway and Switzerland, and 7 countries have said they will not extradite their own nationals under any sort of condition. So this is one question that took a long time. And then finally, there's the question of the political exemption, which was a very welcome development of the European arrest warrant for countries like yours, but also for mine. I'm obviously Spanish, so that you could not oppose the fact that somebody had committed a political crime to avoid extradition. And this, for the question of Ireland and the IRA and ETA in Spain, was very, very important, so that to avoid that terrorists were seeking safe haven elsewhere. This is not part of the Norway-Iceland Treaty either, and it's not likely to be part of any treaty that the UK will be able to strike with the European Union. So that's another question that also took a long time to resolve. So those three questions, in my view, are the reasons why this is taking such a long time to agree.
And they're still pending, so it hasn't been resolved?
No, the protocols on who is going to extradite all nationals are already there. I think the whole thing is already there. It's just a question of whether or not the Italian government or even the Norwegians are going to ratify this treaty, because they are trying to finalize some issues of deciding whether or not this constitutional ban will apply, or whether or not they can have an extradition treaty without a court overseeing it. I think those are the questions pending on some member states. I'm not saying that it's all of them, but some of them are still.
Okay, so progress has been made, but it's been quite slow and complicated, yes. A similar question really on access to the EU Justice and Home Affairs databases. So can you say a little bit more, this may also be for you, Sir Rob, but also for Senora Montero Martinez, what is the relationship between the, for want of a better word, let's call them FDEA countries, although I know it's not relevant in this case because it defines a trading relationship, not a security relationship, but nevertheless, with those countries as that sort of family, what is their relationship with and access to the EU JHA databases?
Well, as Schengen states, they have access to the Schengen Information System the way I explained before. In the context of Europol's databases, they have the same rights as the 20 or so other countries that have signed a formal operational agreement, cooperation agreement with Europol, such as the United States. As I said earlier, that doesn't give them direct access to the databases, but some rights to exchange information.
And so for EEA-EFTA member states that potentially are not members of Schengen, what would be the protocol then? Would a new type of protocol be required because it's connected intrinsically to Schengen membership? Would new arrangements need to be made if, for example, the United Kingdom, on leaving the European Union and after the transition period, went into EEA-EFTA? Would the negotiation of access to databases, for example, be it would be an entirely separate process because, of course, we would not be part of Schengen. So that would be a separate track for the negotiation process.
Yes, I think in the case of Europol, it matters not if they are a member of EFTA or not, in the sense that the arrangements still call for a specific operational agreement to be concluded between Europol and a non-EU member state. So there is no distinction between different types of non-EU member states, at least not in the case of Europol.
And if I may, I think it's important to distinguish in between the Schengen databases, like the Schengen Information System and the Visa Information System, and the non-exclusive, non-Schengen databases, like, for example, Eurodac, but also the PRUM databases, which store DNA and fingerprints, also ECRIS, the European Criminal Records Information System, and the famous PNR, passenger name records. These are non-Schengen databases, and by definition, in my view, they're going to be easier to negotiate than the Schengen databases.
I see. Thank you. That's very helpful. Thank you. Thanks, Chair.